We also have for Los Angeles City, ban the box. LA City has its own law that you can't ask about background information for the employees. Now, LA City, that law is different than the state law. And again, this is where the LA City, you've got to comply with the more restrictive requirements at the city local level. There's some of those disclosures under the state law did not have to be provided in writing. LA City does require some of these disclosures to be provided in writing. So you have to comply with LA City law when you're doing these back and forth with the applicants on whether anything in their background that you're going to rely on to not offer them the job. Those types of disclosures should be in writing to the employee under the LA City law. And we can talk about that offline too if you guys have any questions. So this applies to employers with 10 or more employees, and you're dealing with within the confines of LA City. And here's some of the written requirements that you have to provide. And the city law also has this 5 business day waiting period for the employees to come back with other information that the background check was actually invalid or not about them or something like that, to try to clarify what their background actually is, or maybe you have the wrong person. For the LA City, people operating in LA City, there's again another notice that you have to post. Here's the link to it. You can download the poster. If you use a poster company, they should be providing the poster to you, and it's about this fair chance ordinance. And also, if you have any job applications or job postings online or in the newspaper, you actually have to have a disclosure here. This first paragraph, all LA City employers should be providing that disclosure in any of their job postings. Great, so just some best practices. Train managers to know about the prohibition about asking about criminal history. Fix your applications to stop asking about that type of information. If you are asking about criminal history after you make an offer to the employee, you need to show that it's got some reasonable requirement with their job. So you can't just ask, the back of the house employee about their criminal background check just because you want to ask. You got to show some reason for the need to do the background check. Keep your eye on the local ordinances and make sure that you're complying with those local laws as well. And then again, you need to ensure that you're still, if you are doing a background check, make sure the company that is doing the background check complies with the FCRA or the California equivalent. That's what we were talking about. You're actually making the disclosures to the employee. They have to check the box, have the option to check a box to get a copy of the background check at no cost to them, and meet those requirements as well. Credit checks. Now this comes up. I've been getting this question a lot. Can we run a credit check on employees? Anybody doing credit checks? Good, okay. So generally, you can't do it. It's a very narrow subset of employees that you can actually do a credit check for, and they have to meet the specific requirements. So I don't recommend employers do this basically since 2012. It's a very narrow group of employees that you can do it on. Okay, the new law that California passed again for 2018 on the immigration front was the Immigrant Worker Protection Act. Basically, in protest for the Trump administration and what they're doing on the national level, the California state legislature passed this law with the sanctuary state legislation you probably read about in the news. So basically, employers now need to comply with the federal law on the immigration, the I-9 and ICRA, obtaining the employee's information on the right to work. But now California puts this other burden on employers to comply with state law and not to, basically make disclosures to employees if the federal government comes in and is doing an audit on the I-9s or any type of raid. Employers have to give notice to the employees basically within 72 hours that the employer received notice from the federal government that there's going to be an investigation or an audit, and you have to post this in the workplace for the employees to read in their language that you normally communicate with the employees as well. So it's just something to plan ahead for and know this is out there. Very short deadlines. If you do have a federal investigation on the immigration front, you need to be making these disclosures to the employees now under the state law. Question, yes?
Is this so the employees don't come to work
It could be, yes. Yes, so basically,
So pretty much you're gonna have no employees then?
yes, yes.
So what's more stringent, the federal or the state?
Well, you have to comply with both, and it's a kind of a rock and a hard place. So now you've got the federal requirements that you're complying with, and the state requirements, and this carries some pretty hefty penalties that I'll get to on the next slide. Big penalties for failure to comply with this.
They cannot protect you from federal if they want to come in.
Right, the state can't.
Even though state has announced that they are sanctuary states.
Right. No, the federal law, you still have to comply with federal law. So I haven't seen any litigation on this front, but we'll see. Yeah, it'll be coming through. We'll see how it plays out. So I just wanted to let everybody know about this. And again, there is going to be a template that the state's coming out. The law says they have to come out with it by 2018 about this notice to employees if there's an immigration review of any of the employment records. But it's something to keep your eye on, and if you do get a request for any kind of audit, it should be triggering all types of red flags that you've got 72 hours to start notifying. Now, if there is a particular request, I think this might have been what you were asking about for a particular employee, you need to give the affected employee a copy of the notice of inspection for their I-9 and keep that discreet and just give that notice to that one employee. So you've got requirements for that as well if there's any one particular employee that they're asking about. And then how you deliver that notice to the employees as well. It's all set out in the law. So here's some of the penalties for failing to comply with the new law. The last requirement of the law too says basically you can't do anything that you're not required to do under federal law to check on an employee's immigration status. You can only check on immigration status to the extent federal law requires you to do it. That's all you can do. So you basically can't do anything more than the I-9 or come back and double check people's I-9s because they made a complaint or anything like that. So once they filled out the I-9, that's all you can do to ask about their immigration status. And it's basically an anti-retaliation provision in this law.